Hello and welcome to Daily Politics. On this program, we discuss issues around politics, policy, and governance. I am Shapiro Suleiman, standing in for your regular host, Hamza Idris, who is currently on vacation. As the various governorship election petition tribunals across the country continue to deliver judgments on the disputes arising from the March 18 polls, Nigerians have continued to witness upsets in some cases and affirmations of the mandates given to governors at the helm of affairs at the subnationals based on the substance, evidences, facts and figures arising from the litigations. So far, 17 out of the 28 electoral disputes being heard by the tribunals have been determined, while 11 or so judgments are yet to be delivered. The governorship results in Akwa Ibom, Bauchi, Benue, Delta, Ebonyi, Enugu, Kaduna, Lagos, Plateau, Zamfara, Taraba, Ogun, Sokoto, Cross River, Gombe, and Oyo have gotten the affirmation of the tribunals in those states, while in Kano and Nasarawa, the state governors had their victories invalidated. While legal practitioners and citizens continue to ponder on the intricacies, ambiguities, and fairness of some of the judgments delivered by the tribunals, parties are also taking advantage of their right to appeal to explore superior legal conclusions. Joining us to discuss these issues is Barrister Sam Kabo, a senior advocate of Nigeria. He is a constitutional lawyer with experience in handling election disputes. Good to have you on the platform.
Thank you very much. Thank you for having me.
Right. Before we engage in the conversation, let's take a short break. We'll be back shortly. Thank you very much for staying with us. Barrister, welcome once again.
Yeah, thank you very much.
All right. The election petition tribunals, across the states, the 28 states where election took place on the 18th of March, have gone far in terms of delivering their judgments. So far, a number of affirmations were witnessed, except for the two that were said to have been invalidated. That is, I think, Kano and Nasarawa states. Let's take a look at Kano, which somehow set the pace for, or rather drew the attention of people in respect of the judgment. The tribunal in Kano upturned, the victory of the incumbent governor, talking about Abba Kabir, and declared the candidate of the NPP winner. That judgment has elicited a lot of reactions. Let me get your understanding of the issues around that dispute and perhaps the conclusion.
Well, let me start by saying this is not the time for anybody to worry about the outcomes of the elections, because once you have a matter either in court or the tribunal,
yes,
one way or the other, somebody has to win and somebody has to lose.
That's right.
But the good thing is that our own judicial system allows for appellate review. So this is the first phase, and some are smiling, some are weeping, or some are worried, justifiably so. But let's wait and see what happens at the Court of Appeal, especially for the governorship election that have to go to the appeal court. That will go to the Supreme Court.
That's right.
And for us as legal practitioners, and for those of us who are part of the election petition tribe, who have been resonating around, we are anxious to see some of these cases getting to the Supreme Court, and the Supreme Court giving final word on the issues.
That's right.
Now, I put it this way. For every election petitions, the issues cannot be more than 3.
That's right.
So it has to be one of these 3.
That's right.
And which is, you go and complain to the tribunal that the person who won was at the time of the election not qualified.
That's nomination
for your
issue.
reasons. No, not nomination.
Oh, okay.
That it was not qualified to contest the election because that's what the
Is that what is considered
Constitution
pre-election?
Yeah, the Constitution says you must be qualified, and they give the criteria for qualifications to contest an election, either for State House of Assembly, or for House of National Assembly, or for the governorship and the presidency. So you go there and table these 3 things. That's what Section 134 of the Electoral Act says. That the person who won was not qualified, or the person won, but the election was marred by non-compliance
with the Electoral Act.
The Electoral Act or malpractices. You know? And the third one would be he won on paper, but he did not win the majority of lawful vote cast. The complainant feels he's the one if the mathematics is done right and what is supposed to be taken into consideration and what is supposed to be discarded, when you put the math together, he won.
Yeah.
So those are the 3 things.
Okay.
In the case of Kanu,
yes, let's take the first one, for example.
Yeah, in the case of Kanu,
the nomination issue.
the case was not this one. The case was that some of the polling units, the ballot papers with which the winner was declared did not meet the standard of the law. They were fundamentally flawed in the sense that they were not stamp dated or signed by the presiding officer, because INEC rules and guidelines says it has to be stamped at the back, stamp dated and signed. You know, and their claim is that if those votes are taken aside, the runner-up, who is the petitioner, would have won if we put the math together. And they made their case. The tribunal upheld that part of it and came to the conclusion that yes, it was
when you
APC,
do the deductions and
that APC that won. But the chance is there for the supposed loser at the tribunal to take his case to the Court of Appeal, and the Court of Appeal this time around is not going to hear evidence, it's not going to reopen the case, it's not going to what? Have a review of the reasoning, legal reasoning and conclusions of the tribunal. They're going to look at, is your reasoning concerning each of these issues in line with the law? You know, and if that is affirmed, the judgment would stands. If, on the other hand, they say, oh no, you take into your reasoning is flawed because you don't take into consideration this and that. In any case, this is the extant position of the law. You did not really follow up the threshold for you to reach this conclusion. It will be what? Set aside.
That's right.
And the return will be reaffirmed and the person reinstated. They will now go back to the Supreme Court, and of course, once the Supreme Court give a finality, the Supreme Court is also now going to make a review
of the appellate's decision.
The reasoning, analysis, and conclusions of the Court of Appeal. And in some cases, they will say, oh no, the trial tribunal was right, you are wrong. Or they will say, oh no, you were right. And the tribunal, you know. So that is the way the system works, and that is why I'm saying, don't be bothered for now. Go do your homework, and of course, tell your lawyers to do the job.
It could be either way. It could be restored or affirmed.
Yeah, it could, you know.
Okay. So looking at this basics or fundamentals you raised, issues around the candidate himself,
his qualification,
issues
the way
INEC
conducted the election,
and then
who won the majority of the lawful voters.
That's it. Okay, like in Kano, there was contention around the nomination of the governor. I understand, who was said to have been, joined the party that brought him to power. That is the party he contested on. That he did not. He wasn't a member of the party as at the time he contested the election. That was
sustained?
Not sustained, actually. I think the court did say that this is a pre-election matter. It doesn't have jurisdiction to entertain. But you told us earlier that that is also under the purview.
No. You see, qualification has its own variants. There are, if you look at the sections of the Constitution regarding qualification, you have issues of citizenship, issues of educational qualification, issues of age, membership of political party, and all of that. But if you now say this person was not properly nominated by his own party, you become a busybody because you are from outside. You are outside the party. It's a political family affair. And if anybody from within the family of the party was hurt or would say injured or prejudiced by his own nomination, that person has what we call the local standard to have gone to court before the election, because the Electoral Act says this is the time within which you should ventilate these issues at the High Court, either the Federal High Court, the State High Court, or the Federal Capital Territory High Court. So those are the... And there is another issue too. Section 29 of the Electoral Act says every political party will submit the names of their candidates within 180 days. And when they submit their names within a week or time frame, INEC would publish
those names, right?
Yeah, those people, along with their Form EC9, whereby they made a declaration about their own qualification. Then you have the right within 14 days to challenge whatever assertion they would have made in that form. You have 14 days to challenge it also at the High Court, either the Federal High Court, the State High Court, or the High Court of the Federal Capital Territory. If you don't do that, it becomes statute bad.
Okay, if I understand your explanation, for instance, the petitioner, who happened to be a contestant in the election, has no locus to raise issues around nomination.
I don't know nomination. And nomination is a pre-election matter. The Electoral Act tried to streamline and structure disputes. You have disputes before the election, which arise most of the time from nomination. Each party is supposed to nominate its own candidate, and the nomination usually is an internal election, whereby members within the party would indicate interest, and they meet the requirement for participation in the primaries. They call it the primaries of the parties, and they will go to an election. You saw what happened with the case of the presidential.
That's right.
So that is an internal matter. You don't have a business which is logical. If you are in party A, what business are you? It's of yours to go and poke nose into the affairs of Party B. If they put in a weak candidate or candidate who is not a popular candidate. It's to your own benefits. Take advantage of that at the polls. Don't come and tell me that, oh, he's not qualified because what, he was not properly nominated. And on the issue of membership, here is the catch. Left with me, if I were to be the final arbiter on it, it is a no-brainer to me. It would have been a no-brainer because what else do you need to justify membership if not for the party to sponsor you as their flag bearer to participate in an election? Okay, you understand? But some people would say, oh no, the party was supposed to have sent in its own register. And when you're sending in your own register, that register would now contain all members of the party. But my response to that is that there is no time bar or limit for membership of a party. They did not tell you that within this time it's closed. It's not like INEC who would say, if I don't receive this nomination within this time, everybody is bad because I will close the door. I will no longer accept any nomination. This is a membership of a party. I could be here today and I get fed up with my party. I turn over there and take the microphone and call a press conference that as from today, I buy to this party. I belong to this party. That's right. That's membership.
Okay, but a similar issue, arose during the. Talking about the pre-election issues now. We've seen the legal tussle between the former Senate President, for instance, and a senator who contested under the platform of the APC in respect to same issue of nomination. That he wasn't, he didn't take part in the party primaries and so on, but it became a central issue that it has to go up to the Supreme Court.
There, of course, he had a locus. Okay. But you see, our judicial system in itself is very technical. And this is where I have my sympathy for the judges and justices. Many a times we use logic to ascribe value to decisions of the bench. But that is not their duty. Their duty is to apply the law. And the law is in two parts. The substantive law that says, don't do this, if you do this are the consequences and all of that. Then there is what we call the adjectival law, which is has to do with the way you process the disputes in court.
That is
they call
following
it practice and procedure and evidence.
Practice direction. Practice direction?
Practice and procedure. It's either civil procedure or criminal procedure. And every court has its own civil and criminal procedure rules. And for every lawyer who goes to court, knows that if you are instituting a case that is by itself fundamentally, what would I call it now? By itself, it raises a dispute. And you know that it cannot be resolved fairly, justifiably on the basis of an affidavit. They say you must commence it by or with a writ of summons. And for originating summons, the law or procedure has prescribed and stated the sort of cases that you can commence with originating summons. Because those ones, the facts are not in dispute. That even if they are in dispute, the dispute in itself is not so fundamental.
So in other words, they are stated.
So you can, on the basis of an affidavit, state
those facts.
You understand? For an example, if the issue is as to whether you're a man, you understand? It's hardly contestable. You know, except somebody wants to take it to the ridiculous. But on the basis of this to say, oh, I go and take an affidavit to say I'm a man, my name is affidavit, you know, it's settled.
That's right.
You know, but when you now say somebody has committed fraud,
you have to establish.
It's not something you just state.
That's right.
And swear on affidavit without you having to prove it through the established process of you calling witnesses to establish the fraud and how that fraud by itself was committed by me.
That's right.
And not giving me the opportunity to rebut by also calling evidence and all of that. So every lawyer knows that once your claim is based on fraud, you cannot commence it by an originating summons.
That's right. Okay.
You understand?
Yes.
So because it is inherently what? Controversial.
Right.
It has to be decided on the basis of oral evidence.
That's right. Okay. Talking about the conduct, we substantially, talked about the preliminary issues, that is the pre-election matters, for instance. You talked about the conduct now. The conduct of the election itself can be challenged.
Yes.
In the case, in a manner, perhaps it was conducted, and then in terms of tabulation and all of that, and then the authenticity, if you like, of the votes cast. Like in the case of Kanu, there was dispute around a certain number of votes that were said to be invalid because they were not stamped, signed and what have you. And then the court, the petitioner was able to establish that those votes were actually not properly.
The presumption is that he established that, but it's for the Court of Appeal to determine whether or not he met the threshold for establishing that.
But based on the ruling of the tribunal, perhaps, is that it is established. And then it has to deduct those votes
that is the way
to arrive at its decision. Now, there is also dispute around this. Some would say it is not the duty, perhaps, of the tribunal. It is not for the tribunal to assume the duty of an election management body or the electoral body by subtracting and adding and what have you. I've had cases like that where lawyers would argue that it is outside the mandate of the court to begin to.
No. That's to say the least is actually I don't know whether the word is. I think it's funny to say so because it's very illogical. Because that is the essence. That is your duty. The duty for you to establish that indeed, if this vote are subtracted, you win. How do you establish that you won? How do you establish that the other person did not win by majority of lawful votes, if not for you to lead evidence to convince the court that these votes were invalid? And if you subtract this, if your finding indeed is that they are invalid because they did not meet the standard of the law, and you put them aside, I would win. How would you do that without you doing that? Of course, you're not going to do that in the recess of your chamber when you go to write your judgment. That has to be demonstrated in court, and it must have been pleaded, given the other party the opportunity to reply, and you lead evidence. You lead evidence, and the threshold for the valid evidence to establish that is already stated in the case. You understand? You have to call the polling agents
who also testify.
Who would have to testify and speak to the documents you are relying on for overvoting. Those documents
you have to also obtain them from the electoral body.
If you have your own copy, if you have your own pink copy, that is your counterpart copy, you put it in. But most times we fall back to the certified copy by INEC so that both parties will know that, I have not gone to tamper with the one in my possession. This is INEC. But the law is you have to demonstrate your case in court. It is not for the court to make inferences or the court to rely on the eloquence or articulation or poise or spell binding performance or a spell binding submission of a very brilliant lawyer. No. Evidence. Hard, cold evidence. If you have it, you demonstrate it, you win. And I have said so here over and over that it is highly improbable, but it is possible if you did your work. You have, it is, you see, I have led a team that did that, and I know what it takes to do that. It's Herculean, it's really, really, really tasking.
But it also helps your case.
It is doable. You know, the only thing I have my problem with is that the Electoral Act has given you dates within which to establish your case. You have tribunal, all of them coming back with that idea of conscripting your time to say, oh no, we can't go the full hog of these days. Want to pick some dates, push out some days, and some lawyers would now agree to say, okay, I will establish my case in 10 days. How?
But at what level the tribunal sometimes you find would say that, okay, you provided evidence to support your case. Most cases document, you know, volumes and volumes of document. And you find the tribunal saying that it is not the duty of the tribunal to go through these documents and establish your case for you.
That's what I'm saying. You have to demonstrate this document. The documents, yes, speaks for themselves, but they have to be given live. Somebody has to kickstart them before they start speaking for themselves. You have to relate them to the polling unit, to your case. Somebody has to come and speak to them to say, this is the document relating to this polling unit A, and this is what that document says. And if you demonstrate all of this in court, in the, at the tribunal, you have your day. But it is not just enough to say,
so providing the evidence and dumping them,
no,
it's not enough.
It is not enough for you to come and demonstrate 5. And out of 120, I now say, because I have demonstrated 5, let's the court assume that I have demonstrated the 115. No, you have to demonstrate each and every one, and it's a polling unit by polling unit sort of responsibility that you have.
Okay. In case you're just joining us, we have to go for a break now. In case you're just joining us, the program is Daily Politics, and today we're looking at the tribunal, the Governorship Election Petition Tribunal's verdicts across the country. We're looking at some of the key issues that define some of those proceedings. And I've been interfacing with Barrister Sam Kagbo, a senior advocate of Nigeria, you know, explaining the processes, the procedures, and what is required of a petitioner to establish the case. And then before we also talk about some of the conclusions. We'll take a break. When we return, the conversation continues. Stay with us.
That's great. It's good to see you.
Thank you very much for joining us. If you're just joining, you're watching Daily Politics and Trust TV. You can do well by also following us across all our social media platforms on Facebook, Twitter, and you can also watch us live on YouTube. And our talking point today is the verdicts of the Governorship Election Petition Tribunals across the country. We have in the studio Barrister Sam Kagbo. a senior advocate of Nigeria. Before the break, we're looking at dwelling on perhaps the procedures, the processes and procedures of arriving at some of these decisions that we saw came from the various tribunals. We're looking at looking at Kano as a case study, for instance. One thing that happens to come to stay, some will say, in respect to this judgment, is the application of technology, in delivering some of this. Kaduna also keyed into that. After Kano, we saw Kaduna also go in the Zoom way, and subsequently Nasarawa and so on. The case in Kaduna has also generated a lot of apprehensions and misgivings, some misunderstandings too, even among lawyers and media practitioners who happen to be in court to report this judgment. There was conflict in terms of understanding what the tribunal actually was trying to relate. I don't know how you perceive the entire proceedings.
Well, I have my sympathy for the lay public. But for lawyers, any lawyer who, except for mischief, what happened.
Okay.
Because here it is. When you file your petition, the respondent, that is the person against whom you
brought the petition.
Yeah. He has the right to reply. And in the reply, he has the right to raise objections. And either in terms of the competence of the whole petition itself or some aspect of the petitions, because in their own reasoning, it did not meet the standard prescribed by the law. Because every petition, the room for invention is very small. But it's already a carcass. You just fill in the spaces. Yeah, because what you need to plead is there, how to plead it is there, what to accompany the petition is already prescribed, and all of that. For example, your petition has to limit itself to those 3 grounds. If you add another ground, that ground will be challenged and it will be struck out because it is not
doesn't comply
in the purview of the law.
That's right.
So sometimes too, what if somebody mistakenly filed his petition on the 22nd day?
That is outside
the 21 days. The other person is going to say, oh no, the petition is incompetent and the court should not listen to it. It could raise a lot of objections. But unlike the previous round of election petition trials that give the tribunals the option of hearing those objections, especially those that go to the jurisdiction of the courts, to hear them there and then, so that you will not have to go through the whole hawk of trial, because if the court does not have jurisdiction, and the court will not have jurisdiction if the petition in itself is incompetent. That is, it does not meet the standard of the law for what constitutes a valid petition. You understand? So it has to be valid first before the court would have jurisdiction over it, because the court is not established to hear your own version of election petition. It's established to hear petition as prescribed by the law. You understand?
So what changed now?
So this time around, they said no, irrespective of what kind of objection you have, even if the objections go to the root of the
matter,
the jurisdiction of the court, and no matter the temptation or how flawed it is on the face of it, you have to wait till the end of the trials, you give your ruling first on the objection before the judgment within the same time. Okay. And that is why you have this lengthy judgment. People are saying, because there are so many objections. The objection would come either during the pre-hearing, during the hearing, you have objection as to admissibility of documents, objection as to allowing a witness to testify, objection as for the court to allow a subpoena witness to testify and tender.
All of that have to be determined.
All of those objections would line up. And because there are objections, they would first be determined.
That's right.
Before the substantive matter.
Okay.
And the reason is that, so that if the trial tribunal or the court of appeal that's what we call, or did not do its own analysis very well to the standard of the law, they will no longer have to say, okay, go for a trial. Assuming
those have been already
assuming they dismiss your petition now, and you go up to the Supreme Court, and the Supreme Court say, oh no, it was wrong for it to have been dismissed. Go and continue with the trial. What if by the time you come, the 180 days are over?
So yeah, that has to be concluded.
No, you can't. You're out. I've had two of this one. One in Gombe, 2011. They dismissed my petition because what? Usually when we announce ourselves, we either say, my name is, with profound respect to the Honorable Tribunal, my name is S. Kagbo, or my name is Sam Kagbo, instead of my full name, Samuel Peter Kagbo. The other lawyer say, oh no, the petitioner had no lawyer, because that lawyer who calls himself Sam Kagbo is not on the roll. What we have on the roll is Samuel Peter Kagbo.
So that in its own is...
And indeed, the tribunal dismissed the petition on the basis of that. I went to the Court of Appeal. The Court of Appeal said, may that day never come, that a lawyer would just call himself, and on the basis of that he dismissed it. They now set aside the judgment, but they now appeal. Went to the Supreme Court. The Supreme Court too raised an alarm to say, you are taking technicalities beyond reason.
What it should be.
It's becoming alarming. But by the time when I came, I was in here in Abuja, remaining 3 days for the expiration of the 180 days. By the time I could, I left here in the middle of the night to go to Gombe. This was 2014, when Boko Haram was still there. I had to go by road. The next morning we go and started trial, but for what? You are talking about governorship trial. Just one, they call, just make believe. You are already out. You understand? In 2011, Senator Olero won at the tribunal, but the Court of Appeal said, no, you couldn't have. Go back for the trial. The Court of Appeal did not set up, what do you call it now? It did not set up a panel until the end of the 180 days. When we now went back, they said, oh no, what are you coming to do? 180 days is over.
So if I understand, what they're trying to, those technicalities.
That is to make sure that nobody suffers that kind of impediment or that kind of infernal injury on the basis of technicalities. So everything is here. So it's the same thing that happened in Kaduna. In Kaduna now, they upheld the preliminary objection to say, okay, let's start with the preliminary objection. And they now say, you are right, we upheld it, and therefore the petition is dismissed. But assuming we err on this issue of preliminary objection, let us hear the merit, so that both of them are decided, that will be decided by the appellate court. They now said, after taking everything together, on the merit, you are right.
Okay.
You understand? The petition succeeds. But you are already been indemnified as long as a petition is dismissed on the basis of preliminary objection, irrespective of your merit. It's no longer an issue until you go on appeal. If you go on appeal and your objection, It's the ruling on the objection is set aside. Once the ruling of the objection is set aside, the onus is now on the other party to
on the respondent.
Face, the respondent to face the merit. So both of them are going to appeal.
Okay, so if I understand the layers, if you like, or the petition, the petition in terms of the composition of the judgment was what caused the confusion. People were actually looking at those preliminary objections, rulings on the preliminary objections, and then attributing it to the substantial matter.
If they don't go on appeal, the governor is still a governor, because what? Before they went to the substantive matter, the petition was already dismissed. So once it's dismissed, it's dismissed.
Okay.
So it's like to say, okay, sorry, assuming we are wrong, let's see what would have held. This would have been our judgment in your favor. We would have given you judgments in your favor. You understand? So in the case of Kaduna, both of them now are burning the candles. Because
so it was subject to the review and the determination of the Court of Appeal.
The petitioner only has to deal with the preliminary objection, whereas the
has to do with the
what do you call it?
The respondent
has to deal with the substantive matter.
So both have challenges before them.
The Court of Appeal, Supreme Court may upheld that or it may reverse the thing. It may even find that on appeal they will say you are wrong on the preliminary objection, but you are right. No, you are wrong on the preliminary objection, but you are right on the. Or they could say, oh no,
vice versa.
You are wrong on the preliminary objection. You are also wrong
both sides
on the substantive matter.
Right. Okay.
Those possibilities are there.
That's right. Okay. Let's look at the composition now. Another confusion arose from the panel itself. You know, looking at the number of judges. There was, I think, in the case of the preliminary objections. The petitioner had an upper hand. 2-1. That's right. And then in the
judgment.
Yes, and then in the substantive matter, they're also 2-1.
2-1.
So, but then concern is, if you have 2-1, that is in the concluding decision of the court. Which one suffice? Is it the 2 that is superior to the 1, or how does it work?
Why they make them 3 and 5? So that there won't be any hung or what they call a hung judgment. You understand? There must be a majority. The majority character. The judgment of the tribunal is that of the majority. The one of the minority only has its own moral value. But on appeal, the appellate court may say the minority judgment was right. You understand? But until then, the judgment of the majority. In the Supreme Court, which is the final court, we have so many of those cases whereby 3-2 or 4-3. You understand? But for lawyers, that is normal. But we know you can't come and quote to me a minority judgment. I will listen. I will even continue. Of course, you could make a persuasive this thing, but even though it was in the minority, but I like this reasoning with respect to this particular issue. And I'm not in any way citing it as an authority, but I would urge your lordship to look at the reasoning of the minority in respect of this very particular issue. I think I would want to commend your lordship to have a second look at the reasoning of the minority in respect of this particular issue. You understand? So that could be done, but they are saying no. We are bound by the majority.
That's it. Okay, still talking about Kaduna, for instance, and then looking at the preliminary, if you like, or the objections, the rulings on the objections. I think it is at that point that the tribunal talked about the need for a rerun in some polling units. Now, talking about, is it 24 polling units or so? So how is that implemented now? Since the case has been dismissed, for instance, I mean,
it will not be implemented until the case goes to the Supreme Court.
Okay.
Not now. No, it cannot. It cannot, because it's a suggestion as to what will happen, not now.
Okay.
It is only when If the Supreme Court opposes that, then it will be implemented.
Then they have to come back for
that. But for now, no, that would be foolhardy for.
Okay, so what that means is that if
nothing would happen until you have a judgment of the Supreme Court, nothing would happen in any of these places. The governors are still having their day, and I hope some of them will know that. If they lose at the Supreme Court, there are consequences, especially those of them that would have dipped their hands. If you ask me,
to return,
this is the time for you to be careful and do the right thing, because if the opponent comes in and do a reality check on what you've done,
within this period,
EFCC is waiting for you.
That's serious. And at that point, you don't have any immunity.
No immunity, of course.
Oh, that's serious. Okay. So,
I would have also hoped, or I would have hoped that we had the law stating that if indeed you are not the rightful winner, you go into office. Of course, we cannot reverse all your actions because the state cannot act in a vacuum. But all the money, all the salaries, and the facts of the office, you cough them back.
But we've seen judgments that alluded to that. But how about implementation? We've had cases where lawmakers...
it's for the Attorney General to follow up on it.
Whose cases have been nullified. I mean, you find out that the decision, the pronouncement of the court is that you have to return whatever you've earned because you've earned that in error and so on. But then nothing happens. So if the winner, or the petitioner happen to insist that has to be implemented, it has to.
It has to. I would hope that we accede to that point where some of these people are asked to come and cough out these things, because it would also give a stern warning or be a kind of a check on electoral corruption, because if you know the consequence of saying that while you are in office, if you are not the rightful winner and you got into office, whatever money you would have amassed, directly or indirectly, you have to return them, including all with those of all your appointees.
That's a very, very huge one.
Because by the time they do that, people would have a second thought. But now, even if it's just 1 year, because most times you are having the full year, 8-10 months, it's a lot. Assuming within that 10 months you are receiving 5 billion as security votes, you are rich for life.
That's right. Okay, looking at the time frame for the implementation, now that the case has been dispensed with at the lower tribunal, now the appeal courts, the appellate courts has to, determine these appeals. How long is it going to take for that?
2 months.
2 months. Okay. Within these 2 months, again, if the petition or if the parties are not satisfied, they go to the Supreme Court.
But it's only the governorship that will go to the Supreme Court. Those of the State House of Assembly, they end at the Court of Appeal. And the good thing is, I would just wish that they free the Court of Appeals now. It is just imagine for every one of this myriad tribunals scattered across the states. All of those panels, you have some states have 2-3 panels of 3 judges and magistrates. All of these are taken from courts.
So in other words, they're stabbing the regular courts.
You can't imagine what it is. For some of us, we are so confused that sometimes you don't even you lose track of your cases. Case management in the office. Sometimes you just see a case. This case is still pending. You don't have an idea because...
Is it about the deficits of the members of the bench?
I think we would have to do a rethink on the constitution of electoral tribunals. there are so many retired judges and justices who are still strong, who can do that job. They should have them.
They should be invited.
And there is also nothing wrong
Yeah.
in drafting senior advocates.
Okay, to also...
Yeah, because you see, for senior advocates, for an example, or senior lawyers, let me don't...
Yeah, just with the...
Yeah, because that would be... because there are...
Some would say it's self-serving, yeah.
There are non-senior advocates that are smarter than us. You understand? I can tell you that. And it's a matter of forte or area of disposition.
Yeah, that's right.
Some people are really grounded and all of that. Get them to... Because, you know why? You dare not misbehave. If you take bribe, you are off the roll.
That's right.
The consequences are too there, much even more than that of the judges. Because the judges, you have to go through the NJC and all of that recommendation, and sometimes you have to go back to court to challenge it and all of that. But once you go to the disciplinary committee, once you finish right there, from there to the Supreme Court, you are off. So there is that kind of sword hanging on you for you to misbehave, no matter how greedy you are.
So there's need for...
so that they free the courts of these things. I don't know where we got the idea. For a whole... And the moment this round is finished, another round is coming, pre-elections. What do you have? The courts are still struggling. The Supreme Court. These are people who are starved of manpower, and are still struggling with cases of 2001, 2000, and this. What would I say?
Yeah, but we had series of judicial reforms. I mean, and reforms generally in the country. The Ways panel did a lot in terms of, addressing some of these issues.
Sorry, for the electoral.
For the electoral.
But you see, there was that disconnect between the effect of having these tribunals on the mainstream courts, because you are pulling them out of that.
But it's a special case anyway. It's something that requires special attention.
Yes, special attention, but we have other jurisdictions that have what they call constitutional courts. It's constitutional courts. Especially here that we have this adversary system that has to do with you go and carry not so young men, you put them through the rigors of having to see sometimes 7 days a week for 6 months.
Right.
And some of these judgments, I just read the judgment from Ogun State, 400 and something
very
pages.
bulky, yeah. Even the proceedings
written by one person with a few pages of concurrent by the other two. By somebody before you could have been a chairman of that panel means that you are way up there and you are no longer a young man.
Right. Okay. Lastly, we're looking at. We said we wanted to look at Nasarawa, for instance. It was the recent judgment, and this shows that even the incumbent governors, governors, could also lose their seats.
I have said so. There is no sacred cow. Let's give it to the judiciary.
Okay.
Let's give it to these people. Of course, some of them betray the trust. Some of them are not men of honor. But the majority. The majority are the most hard-working people today in Nigeria. I can tell you what they go through. I would always challenge my colleagues. I say, try and write 5 briefs in a row or 5 addresses in a row and see whether you will not see the doctor. But these people, this is their daily routine. They hear cases, they retire.
In most cases, we do them manually and all of that.
They do. Take notes of all of this. They hear all sort of banter and all of this. Some of us will wear them out. Sometimes I sit there and say, there is that skit. I say, I could have just killed somebody now. And that skit, I say, I was there. I say, oh no, God forbid, I won't be a judge because what? Many lawyers will go to jail.
Right.
They annoy you. out of your wits, and you go through all of that, you still have to go and see that, and you still have to advise yourself to say, the lawyer who was that irritating is not the litigant.
Thank you very much.
It's not the litigant. The litigant is there, and therefore I cannot transfer my malice or whatever it is to the case. I have to.
It's a very delicate, and of course tasking and
with
demanding
the
job.
dictates of justice.
We should appreciate our judges for that.
Believe me, please do.
Thank you very much, Barrister Sam Kago, for talking to us on Daily Politics. Today we'll be looking at the tribunal's verdict across some of the states and the issues that define, if you like, the proceedings and the conclusions, even though, it is not yet over. There are two other layers for the governorship election petitioners, if you like, or parties to go through: the appellate court and then the Supreme Court as well. Thank you very much once again for your informed perspectives.
Thank you for having me. It's always an opportunity that I don't take lightly.
That's right.
Thank you very much.
Thank you. We sincerely hope that you found the conversation engaging and informative. Be sure to join us on Daily Politics live, airing every weekday from Monday to Friday, with a special edition every Friday. During these special editions, we welcome your active participation, as you can call in to share your valuable thoughts on pressing issues in the polity. Once again, thank you for watching. We look forward to having you yet on another exciting edition of Daily Politics. I am Shafiu Suleiman, thanking you for staying with us.